All right, are you Quentin Miniger appearing there from the jail? All right, this is case number 25 CR 105, State of Ohio versus Quentin M. Miniger. This is a pretrial being conducted by Zoom. Mr. Miniger is appearing from the jail. His attorney is Catherine Hatner, appearing from her office. Appearing on behalf of the state is Assistant Prosecuting Attorney Adam King, and is charged with aggravated possession of methamphetamine, failure to comply with order signaling a police officer. This is a first pretrial, final pretrial set for the 10th of June. Have a trial date of June 25th. I don't see where there's been any request for discovery, Ms. Hatner. Oh, yeah, there it is. Okay. Have you complied with that yet, Mr. King?
Yes, Your Honor, we complied back on May 18th.
All right. Well, it hasn't made it to the file, so. And you received it, Ms. Hatner?
Yes.
Okay. Do you anticipate any pretrial motions, Ms. Hatner?
Not at this time.
All right. Well, any pretrial motions and your discovery compliance will be due by final pretrial. Has there been a written plea offer provided?
Yes, Your Honor.
I have not yet conveyed it to my client, so I'll get out to see him before the end of the week.
All right. Any other matters that need to be discussed at this time?
There you are.
Not to say.
All right. Thank you. All right, this is case number 26 CR 38, State of Ohio versus Noah J. Boggs. Are you Noah J. Boggs appearing there from the jail? All right. Turn volume a little bit here. All right. This is a pretrial, final pretrial being conducted by Zoom. Mr. Boggs is appearing from the jail. His attorney is Catherine Hatner, appearing from her office, and representing the state from the prosecutor's office is Adam King. Defendant is charged with aggravated trafficking in methamphetamine, a third-degree felony, and theft by deception, a first-degree misdemeanor. This is a final pretrial. We have a trial date set for June the 25th. See, the discovery has been provided by the state, and did you file your compliance yet, Ms. Hatner?
If not, I'll get that in.
All right. Well, have it in by the end of the week. Are there any pretrial motions? I don't see any.
There are not.
Okay. All right. So where do we stand on this case?
We've recently had some negotiations. I need to go back and see. I saw my client yesterday evening. I need to go back to discuss those with him.
Okay.
I need some clarification on something. I got that clarification this morning, so I need to go back and discuss that with him and see whether we have a resolution or not.
All right. Well, we still have a month of trial date, so this is a final pretrial. So if there's any resolution of the case, then contact the assigned commissioner and we'll get a date set. All right. Anything further from counsel?
There you are.
All right. Thank you. All right, this is case number 26 CR 49, State of Ohio versus James Franklin Gregg. Are you James Franklin Gregg appearing there from the jail?
Yes, sir.
All right, this is a pretrial being conducted by Zoom, first pretrial. Mr. Gregg is appearing from the jail. His attorney is Catherine Hatner, appearing from her office, and appearing on behalf of the state from the prosecutor's office is Adam King, assistant prosecutor. Defendant is charged with 3 counts of rape. Mr. King, has the alleged victim or representative of the alleged victim or victims been notified of the time, place, and purpose of this hearing?
Yes, Your Honor. The representative is monitoring the hearing on YouTube.
All right. So this is the first pretrial, final pretrial set for June 17. We have a trial date on July the 9th. I see that the state did provide discovery and a request of discovery. It looks like on the 21st. You received that, Ms. Hapner?
Yes.
All right. Well, your discovery will be due by the final pretrial. Are you anticipating any pretrial motions, Ms. Hapner?
Not at this time, but I'll reserve on that.
Okay. Well, you have the right to file any up until the final pretrial if you determine that there are some should be filed. Has there been a written plea offer provided yet?
Yes, but that was just provided yesterday, Your Honor.
Okay. All right. I assume you haven't had a
Yeah,
chance.
see, it's probably still in my box at the common police court. So I'll pick it up and get out and see my client.
Okay. All right. Are there any other matters then that need to be discussed at this time?
Not from the state.
There you are.
All right. Your attorney will be out to see you then, Mr. Gregg. Thank you. Junior, case number 26CR40. This is a pretrial being conducted by Zoom. Defendant's attorney is Catherine Hapner, appearing from her office. Assistant Prosecutor King is appearing from his office. Mr. King, or Mr. Morris is supposed to be in the jail in Clinton County. Anybody have any information on that?
He's not in custody in Clinton County anymore, Your Honor.
Okay. Ms. Sturgill, Mr. Benson, are you aware of what's going on with him?
Yeah, yes, sir. So late yesterday afternoon, maybe around 3 o'clock, I got an email from Clinton County. They've done a PSI on him, and they were reaching out to get information from us. I started investigating and saw that he had been released, and he has not made any contact at all with our office. He had a negative drug or a positive drug screen that they were waiting on lab confirmation, and then they were actually going to issue a habeas on him if it came back from lab positive. So, again, he hasn't made any contact with us. He has been seeing Clinton County.
All right, so when he was released from here on the 17th of April, he never reported?
No, sir.
All right. Ms. Hapner, have you had any contact with him?
It was my understanding that when he was released from Highland County, he went straight to Clinton County.
Yeah, but he's not there anymore. He was released from there. Yeah.
Well, my understanding is he was just released from there yesterday, possibly. I've had some communications with the prosecutor's office.
All right. But you've not heard anything from him?
Not from him directly.
All right. Ms. Sturgill, you're aware when he was released?
I do not have the release date. I just know he reported to their office yesterday for his PSI. I could look that up in just a minute.
Well, in any event, he was notified that today would be his hearing, and he did sign an assignment appearance notice for that on his. Actually, that was supposed to be on the 19th. That's right, and then it was continued. However, he was also to comply with pretrial supervision, so. Okay, I was looking here. We had him brought back on May the 6th for the pretrial. He wasn't in their custody then. Maybe you found anything there, Miss Turtle?
It looks like he pled guilty on 5-7 up there. 5-8 there, stuff's a little hard to read. And I don't have the access to the jail site right this minute, but his last court entry with them was 5-8.
Okay. All right. Well, Mr. Morris was ordered to comply with pretrial supervision, and the order provided in the arraignment entry is to report upon his release, and so regardless of what day he's released, he's not been reporting. So the court's going to order a capious for his arrest, and when he's found, then we'll bring him back before the court. All right. Anything further from counsel? All right. All right, just case number 24, CR 131, State of Ohio versus Tammy Sue Dietrich. Are you Tammy Sue Dietrich, appearing there from the probation department?
Yes.
All right, this is a hearing being conducted by Zoom. Ms. Dietrich's attorney is Catherine Hapner, appearing from her office. Appearing on behalf of the state is Assistant Prosecuting Attorney King. This is a hearing on an intervention in lieu of conviction motion and plea, and I have received a report on that, and it appears Ms. Dietrich is enrolled in the REACH program and willing to report dated 25th of May. She's compliant. Now, Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, we are.
And are you all right with that, Ms. Dietrich?
Yes.
All right. If at any time during this hearing you would like to speak with your attorney, since you're not seated in the courtroom next to her, just tell me. I'll put the two of you into what's called a breakout room. It'll be just you and her on the screen. No one else will be able to see you or hear you. Okay?
Yes.
All right. Now, I have a proposed plea of guilty and intervention in lieu of conviction form here, and I'm going to hold up the first page of that has your case title, number, and the plea of guilty form. The title and the document. Ask, do you recognize that? Yes. On page 3, there is a sentence that reads, I enter this plea voluntarily. Right below that, there's a signature defendant line. I'm looking at what appears to me to be signature of Tammy Dietrich. I'll hold that up to the camera, and is that your signature?
Yes.
Do you recall when you signed this document, Ms. Dietrich?
Yes.
When was that?
It was made on ice and knocked down.
All right. Now, when you signed it, did you understand that it was an agreement to plead guilty, meaning there wouldn't be a trial, and then the next step would be disposition?
Yes.
And before you signed this, did your attorney go over with you and explain it to you?
Yes.
And since it's been about a month or so since you signed it, have you had any change of heart, or is this still what you want to do?
Yes. No change of heart.
You want to go forward?
Yes.
And you're doing that voluntarily?
Yes.
All right. Now, generally, Ms. Dietrich, when somebody is found guilty or pleads guilty, if there's a trial and found guilty, or if there's a plea of guilty, then the next step would be a sentencing. And in this case, the charge is a fifth-degree felony of aggravated possession of methamphetamine under 2925.11. That carries a possible sentence of between 6 and 12 months of incarceration and a fine of $2,500, or community control or probation for up to 5 years. Now, there is a process under the law that the court has approved, and we have a program set up for it. It's called intervention in lieu of conviction. What that process is that if a person pleads guilty to a charge that was committed in part or whole because of that person's abuse of drugs or alcohol or due to any mental illness, then instead of being found guilty when they plead guilty, if they are in an appropriate certified treatment program, which you are at REACH, and if they comply with certain conditions that the court imposes for supervision for a period of up to 5 years, I only go 2, but it could be legally up to 5 years. If that person completes the intervention program, which includes not using alcohol or drugs except for those which have a lawful prescription for a period of at least 1 year. But if you complete your treatment program, you comply with that condition and the other conditions that I've set for this program that the probation department oversees, then you have the opportunity to have the charge dismissed. So what happens is that you plead guilty, but instead of finding you guilty, the court stays the case. A stay means that it's stopped, and it's basically just put on the inactive docket for the court, pending the report from the probation department and your treatment facilities as to your progress in the program. And if they notify the court after 2 years or less, if they feel that you've accomplished your goals and what you need to do, then they notify the court, and then the court dismisses the charge. And so even though there's a guilty plea form in the file, you're not considered to be a convicted felon because you haven't been sentenced. And if you complete the program, comply with the conditions, the charge is dismissed. And then the court will order that the record be sealed unless there's some event that happens after that would render that not appropriate under the law. So that's the advantage for you, is you have the opportunity to avoid having a felony conviction in this case. Now, in the event that it's alleged that you have failed to comply with those conditions, then the probation department has to file a written notice of that with the court and give you a copy. There's a hearing set. You'll have an attorney at that hearing, and if the outcome of the hearing is that you failed to comply, then at that time the court will terminate you from the program and find you guilty. And then at that time, the court could sentence you to 6 to 12 months incarceration, fine you $2,500, or put you on community control for a period of up to 5 years. Community control or probation is actually more strict and there are more conditions, but it operates the same way. And if during that period of time probation felt that you were non-compliant, they would file a written allegation with the court. You would have a copy of it given to you. There would be a hearing in which you could have an attorney. And if the outcome of that hearing was you failed to comply, then at that time the court would terminate you from community control and then sentence you to 6 to 12 months and fine you $2,500. If you were to be sentenced to prison, then upon completion of that prison term under the law, the adult parole authority does have the option, if they want to exercise it, put you under post-release control supervision for a period of up to 2 years under a parole officer on the terms they set. And if during that period of time they determine you've not complied, then they could return you to prison to make you serve as a sanction an additional period of up to half of the prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new case would impose upon you, that judge could also sentence you for committing that offense on post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes.
All right. Now, the charge in this case alleges that on or about February 1, 2024 in this county, You knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, methamphetamine. So that's the charge with the penalties I've described. Do you understand what it is you're charged with, what the state said you did, when, where, and how they led you did it?
Yes.
Have you discussed the nature of the charge, the evidence in a case, possible legal issues in case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to make you plead guilty here today?
No.
Now, on page 2, it indicates you'll enter a plea of guilty to the indictment. The state recommends intervention in lieu of conviction. Other than that, have you been promised anything to plead guilty here today? Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
All right, now, you have certain rights you must understand before I can accept a guilty plea from you. First, you have a right to counsel, and Ms. Hapner is appointed to represent you. Her appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you're likely to provide. So, if you decide you don't want to do this, that you want to defend against the case, she'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes.
Now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, 12 of those folks, the evidence is presented, and then the judge instructs them on the law. And then that jury of 12 decides by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means give up in writing the right to have a jury trial, in which case you would have what's called a quarter bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution and laws of the state, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes.
Now, under the law, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes.
Now, under the law, you have a privilege against self-incrimination, which means you cannot be forced to give testimony in this case at any time, including trial. No one can ever make you testify. The judge can't, the prosecutor can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. In fact, no one's even allowed to comment about it except in one situation. If there's a jury trial, you do not testify. The judge instructs the jury that because that is your constitutional right, they cannot consider the fact that you did not testify for any purpose. Do you understand that?
Yes.
Now, under the laws of this state and the Constitution, you are presumed innocent of the charge till proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence on your own behalf at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that? Right now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I just described. If you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed a crime, and that plea waives, gives up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, a guilty plea would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you in open court and cross-examine them through your attorney. You would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. The waiver give up your privilege against self-incrimination because if you say you're guilty, that's what defines you guilty. The waiver gives up the presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also gives up any right to file an appeal you think you may have had up until this point in the case. Now, if at some point in the future you would be sentenced to the maximum or under other limited circumstances, an appeal could be filed. Any appeal that you would want to file would have to be filed within 30 days of the sentencing entry being filed. Do you understand all of that?
Yes.
Are you a U.S. citizen, Ms. Dietrich?
Yes.
Now, do you have any questions about the charge and the possible penalty? Do you understand them? Do you have any questions about the intervention program or what's required for you to do during this 2-year period?
No.
You understand?
I understand.
Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
You understand the plea of guilty, what it means, what will happen if you enter that here today?
Yes.
All right. Is there anything you'd like to speak with your attorney about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the agreement we just went over?
Yes.
All right. Then as to the charge which alleges that on or about February 1, 2024 in Huntington County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, the charge of aggravated possession of methamphetamine, 5th-degree felony, carrying a possible penalty of 6 to 12 months incarceration and a fine of $2,500. How do you plead?
Guilty.
All right. Thank you. The court finds on this day, the open court defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The plea is accepted and ordered filed. The court, however, stays the criminal proceedings on the basis that the defendant does qualify for this program, that she is in an appropriate certified treatment program, that her drug use was a factor that led to the commission of the offense, and intervention will not demean the seriousness of the offense and will substantially reduce the likelihood of future criminal activity. She's not a repeat or dangerous offender. She's eligible for community control sanctions. And the state, through the stipulated questions as stipulated, she is eligible, and that does appear to be the case based on the report from probation. Therefore, as I said, the proceedings are stayed. The defendant is hereby placed on community control under the intervention in lieu of conviction program under the supervision of the probation department. You're to comply with all the conditions that the probation department will give you, which I have approved and are part of the program and are incorporated herein. You'll be required to successfully complete your intervention plan, including and treatment plan, including that you're not to use alcohol or drugs of any sort without a legal prescription during that period of time, at least for 1 year. You are to pay any fees and costs for the proceedings. And if you successfully complete the program, then at that time the court will dismiss the charge against you. Even though you pled guilty, there will be no finding of guilt, and the court will set the matter for a hearing to seal the record. If it's alleged you have failed to comply or complete any conditions or programming, then the court will hold a hearing after you've been given a written notice of that and appear at a hearing at which will be represented by counsel. And if at that time the court finds that you failed to comply, then you can be terminated from the program, and then you would be subject to being sentenced to 6 to 12 months of incarceration, a fine of $2,500, or community control for a period of 5 years. All right. And it's also ordered to pay the court costs, including the $50 deposit for the sealing fee if you complete the program successfully. Is there anything further from counsel?
No, Your Honor.
All right, this completes the case then. Ms. Dietrich, you're no longer under pretrial supervision or house arrest. You're under these new conditions. Report to the Officer Benson there, and she'll schedule you your appointment for intake under the new conditions. Thank you. All right, we have Dana Barnes there, probation. Do you have a plea form on this case? I don't see it. Did you see one in here, Beth?
I don't,
There should be, because it's not on my file anymore.
I have not received one.
Did you see one in here? The bailiff said he didn't see it.
There wasn't one brought over, Your Honor.
Okay. All right. Well, we're on record on Dana Barnes, 26 CR 13. That's Ms. Barnes, you're appearing for probation?
Yes.
All right. Well, this is set for a hearing on the ILC. Ms. Barnes' attorney is Catherine Hapner, and Assistant Prosecutor King is representing the state. They're both appearing by Zoom. I do have a report that indicates that Ms. Barnes is scheduled to complete Georgia Harris House on the 21st and then go into transitional. Are you still at Georgia Harris, or are you in transitional now?
No, Your Honor, I'm a transition on an IOP.
Okay, and where's that?
Reach and Greenville.
Reach.
Tomorrow.
Okay. All right. Well, counsel, I have an arraignment at 9:30 and a civil motion and a hearing at 10. So if you want to take a recess, and can she come over to your, do you have a form over there, Ms. Hapner?
No, that's what I'm saying, it's not my file.
You didn't make a copy?
No, I didn't.
Okay. Well, if somebody wants to get a form and get it signed, we can do it this morning, or if you want, we can reschedule.
I'll come over to the courthouse, and
Okay.
she don't have a form for me, I'll pick it up and pick
All
up
right.
my stuff from the rack, and then.
All right, well, why don't everybody just come to the courtroom and we'll just do it in person then. So you come on over here, Ms. Barnes, your attorney will come over, and Mr. King will get the form reprinted, and Ms. Hapner can go over it with you.
Okay.
All right,
Thank you, Your Honor.
all right, thank you. All right, we're back on record. Case number 26CR013, State of Ohio versus Dana M. Barnes. We are assembled in the courtroom. Mr. King is appearing on behalf of the state. Ms. Hapner on behalf of the defendant. You're Dana M. Barnes?
Sorry?
You are Dana M. Barnes?
Yes, Your Honor.
All right. All right, the defendant is charged with a single count of tampering with evidence, a third-degree felony. The defendant filed a motion for intervention in lieu of conviction, and I have before me the stipulated questions for intervention, and those were just signed here this morning. Is that correct, counsel?
That's correct, Your
Yes, Your Honor. All right. And Ms. Barnes, you signed these, and your responses to all these questions accurate?
Yes, Your Honor.
All right. The court then has also received a proposed plea of guilty and intervention, granting intervention. As charged, the tampering charge is not eligible, but I believe that, looking here at the plea form, it appears the state's going to reduce it to attempt. Is that correct?
That's correct, Your Honor.
All right. And that's correct?
That's correct.
All right. So currently you're charged with a third-degree felony, which carries possible sentence of 9 to 36 months and a fine of $10,000. But more importantly, it doesn't make you eligible for this procedure. So under the law, an attempt to commit an offense is 1 degree less than the charged offense, and that then reduces this charge to a fourth-degree felony, which carries a possible prison term of between 6 and 18 months and a fine of $5,000, and makes it eligible for this program. So you understand that?
Yes, Your Honor.
Okay. And you're in agreement with that being reduced so you qualify?
Yes, Your Honor.
All right. So normally, Ms. Barnes, well, it's proposed here that you're going to plead guilty in exchange for being put into the intervention program. Normally, if a person pleads guilty, they are found guilty, there is then a sentencing. And the sentencing for this offense could be between 6 and 18 months imprisonment, a fine of $5,000, or it could be community control or probation for a period of up to 5 years. And if that occurs, then that person then is a convicted felon, and it's so shown in the public records. Now, under this procedure that is being proposed here, it's called intervention in lieu of conviction. And what that means is that if a person committed an offense due in part or whole because of their use of drugs or alcohol or mental state, then, and if they are in a certified treatment program, and you are now, you've completed a residential at Georgia Harris, and now you're in the REACH aftercare. And so those are certified treatment programs. And if you comply with those, that treatment, which includes that you have to not use alcohol or any kind of drug without a lawful prescription for a period of at least 1 year, and you must comply with certain supervision conditions that the court has established for this program, and those are not as numerous nor are they as strict as if you were convicted and put on probation as a felon. And now the law provides that the court can order this to be up to 5 years. I always order 2 years. I think that's sufficient time to determine if the person is going to be able to change the way they're living. And if you comply with those conditions that the court has and complete or if not complete, at least stay in compliance with your treatment plan, then upon notice of that from the court or from the probation department through the prosecutor's office, the case is dismissed. Because even though you pled guilty, there was no sentence. And so when you plead guilty here, the court stays the case, which means it stops waiting for the report on your performance. And if your case is dismissed, then the court sets a matter to seal the record because there's no need to have it in the files unless something happens after that, which I've not had happen in 18 years, almost 18 years. But in any event, then it gets wiped off the records. So that's the advantage to you. You get to avoid having a felony conviction. And even though there's a paper in the file that says you pled guilty, unless you are found guilty and sentenced, you are not guilty even though the form is in the file. So that's the advantage to you. Now, the disadvantage is that this is your last chance to stand on your not guilty plea and defend against the charge. And so that's why we go through this process. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No, Your Honor.
Are you currently on probation or community control for a felony for
No,
any
Your
other court? Right. Now, the way that the program works is that you would plead guilty and you'd be put under these supervision conditions. And if during the period of time you're being supervised, the probation department and the prosecutor feel that you're not compliant, they have to file a written notice out to the court and give you a copy. There's a hearing at which you have an attorney. And if the outcome of that hearing is that you have failed to comply, then at that time the court can terminate you from the intervention lieu of conviction program and then would sentence you. At that time, there'd be three possibilities. Could be a prison term of up to 6 to 18 months, could be a fine of up to $5,000, or there could be community control or probation for 5 years under more strict conditions. Now, in the event that you were placed on community control or probation, it works like this, although the restrictions are more numerous and they're more strict. But the same thing applies. If you comply with it, then the case is terminated and you're released from probation. If you are alleged not to have complied, then the state has to file a written notice out with the court and give you a copy. There's a hearing, and at that hearing you have a right to have counsel. And if the outcome of that hearing is you fail to comply, then at that time the court can revoke your community control and sentence you to 6 to 18 months and fine you $5,000. And if you were convicted of another felony while on community control and sentenced to prison, the sentence in that case, in this case, could be ordered to be served consecutively to one another. You understand that?
Yes, sir.
All right. Now, if that should occur and you go to prison, then under the law, the Adult Parole Authority has the right, once you complete your prison sentence, to place you under what's called post-release control supervision for a period of up to 2 months. And if during that period of time they determine that you've not complied, then they can return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. But if you're convicted of a new felony, then in addition to whatever sentence the judge in that new felony case could impose, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is granted or greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
Like nursing, teaching.
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept a guilty plea. First, you have a right to counsel. Ms. Hapner has been appointed to represent you since you didn't have the money to hire your own attorney. Now, that appointment wasn't to simply work the case out, but provide whatever defense could be available under the law that you would like to provide. So if you decide that you don't want to do this, that you want to defend against the charge, she would continue to be your attorney and represent you, including a trial, if that is what you want. You understand that?
Yes, sir.
Now, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, they're instructed on the law, and then that jury decides by unanimous verdict, meaning all 12 have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. In that case, you have what's called a court or bench trial, meaning that instead of a jury, it's the judge who hears the evidence, applies the law, and decides whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the law, you have a right to confront the witnesses against you in open court, to cross-examine them through your attorney. That means that any witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the law, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. That forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, Your Honor.
All right, now, you have a privilege against self-incrimination under the law, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it during the trial or the proceedings in the case, except in one situation. If there's a jury trial and you elect not to testify, then the jury is instructed that because you have that constitutional right, they cannot consider the fact that you did not testify for any purpose. Do you understand that?
Yes, Your Honor.
Under the law, you're presumed to be innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Originally entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits it, and it's a crime that you committed that crime. That plea waives gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives gives up your right to a jury or court trial, waives gives up your right to confront witnesses against you and to cross-examine them through your attorney, waives gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same to the state. The waives gives up your privilege against self-incrimination because if you say you're guilty, that's what usually defines you guilty. Waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also waives gives up your right to file an appeal on any alleged violations of your rights you feel could have happened up until today. Now, if you are sentenced at some point in the future because you didn't comply to the maximum sentence, or under other certain circumstances, you can file an appeal. You have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, you have any questions about the intervention program and what will be required of you?
I do not.
You understand?
Yes.
Any questions about the charge and possible penalties?
No.
You understand those?
Yes, sir.
You understand the plea agreement of recommendation, what's expected of you?
Yes.
Any questions about your constitutional rights?
No, Your Honor.
You understand those?
Yes.
You understand the plea of guilty, what it means if you enter that here today in this case?
Yes, Your Honor.
Is there anything you need to speak with Ms. Hapner about before we go any further?
No, Your Honor.
Is it your decision then to withdraw your not guilty plea, plead guilty to the amended charge of attempted tampering with evidence as set forth in the plea agreement?
Yes, Your Honor.
All right, then, as amended, that charge then would read that on or about January 2, 2026 in Highland County, Ohio, that you did engage in conduct which is successful, knowingly or purposely engage in conduct which, if successful, would have constituted or resulted in the offense charged in the indictment of tampering with evidence, which alleges that on or about that date, an official proceeding investigation in progress or about to be or likely to be instituted. You did make, present, or use any record, document, or thing knowing it to be false with purpose to mislead a public official who is or may be engaged in such proceeding investigation with purpose to corrupt the outcome of any such proceeding investigation. Violation of Section 2921.12A2. So the violation is actually under 2302A. I had a blank there. And so that means that you attempted to do those things. And that makes it the fourth-degree felony with the penalties I've described. And to that charge, how do you plead?
Guilty, Your Honor. Guilty, Your Honor.
All right, thank you.
Sorry.
No problem.
This is my
All right. Court finds that on this day in open court, the defendant was informed of her rights and made no intelligent voluntary waiver of the same pursuant to Court Rule 11 and entered a plea of guilty. court to the amended charge of attempted tampering with evidence. The court finds that defendant's drug usage was a factor that led to this offense, that intervention would not demean the seriousness of the offense and would substantially reduce the likelihood of any future criminal activity. She is in an appropriate certified treatment program. She is otherwise eligible for community control, is not a repeat or dangerous offender, and meets the criteria for this program as indicated by the stipulated questions submitted by the parties. Therefore, the court will not make a finding of guilt at this time, but instead will stay the criminal proceedings. Defendants placed on community control under the program, under the probation department supervision for 2 years under the terms set by the court. You'll be required to comply with all the terms and conditions that they provide you that have been approved by the court. You're required to successfully complete your intervention plan and treatment plan, and that includes that you must abstain from using alcohol or drugs unless you have a legal prescription for those for at least 1 year. You're required to successfully complete or comply with your intervention program and the conditions of community control. If you do that, then you also will pay the court costs, including the $50 deposit for a sealing fee if you complete the program successfully. Now, in the event that you successfully complete the program and comply with these conditions, then upon notice of that from the state, court will dismiss the charge against you. You'll have no criminal record in this case, and the court will set the matter for a sealing hearing. If it's alleged that you have failed to comply, then the probation department will give you a written notice of that through the prosecutor's office. They'll file it with the court. There will be a hearing at which you'll have an attorney. If the outcome of that hearing, if you fail to comply, then at that time you could be sentenced or could be found guilty and then sentenced to a term, and it says 9 to 36 months. We need to change that to 6 to 18 months and fine you and change it to $10,000 to $5,000. Fine you $5,000. All right. Is there anything further, counsel?
No, Your Honor.
All right. That completes the case. Ms. Martin, no longer under the pretrial supervision conditions, house arrest, etc. You'll go talk to probation officer Benson here about your appointment to go through the intake to be transferred over to the new conditions. All right. Thank you.
Thank you.
All right, this is case number 26 CR 54, State of Ohio versus Amy M. Rickman. Are you Amy M. Rickman?
Yes, sir.
All right, Ms. Rickman, you were indicted by the grand jury on May the 5th on a charge of aggravated possession of methamphetamine, a fifth-degree felony. Now, I know there was a summons issued for you, and then you weren't served. There was a warrant issued, and then I believe you came to the sheriff's office thinking that you were going to pick up your summons, and they indicated you had an indictment, but I understand you had some medical issues, so the court vacated the warrant and set your arraignment today, and you've appeared. Now, I believe you were just now served by the bailiff because they, since the paperwork they had out there was a warrant, if they served you, they had to take you into custody. And so that's why you weren't served out there. Under the law, you have a right to wait 24 hours before we go forward with your arraignment to give you the chance to talk to an attorney. I doubt if you have an attorney and you filled out a request for one. I'm going to appoint you one. But you can wait and come back tomorrow morning if you would like to do that. Or you can waive your right to wait 24 hours and we go ahead and proceed with an agreement this morning. I'm going to enter a plea of not guilty on your behalf, so you're not going to be in any danger of anything. I'm going to release you on your own recognizance. So are you willing to go ahead and waive that 24-hour right?
Yes, sir.
All right. All right. So the charge alleges that on or about August 11, 2025, in this county, you knowingly obtained, possessed, or used methamphetamine, which is a fifth-degree felony which carries a possible term of incarceration between 6 and 12 months and a fine of $2,500. You're entitled to have an attorney, and I have your financial disclosure form here. You're unemployed. Everything on this is correct?
Yes, sir.
All right. So the court will find that you are entitled to appoint counsel, appoint attorney Danielle Witt of Hillsborough to represent you. In the absence of your attorney, I will enter a not guilty plea on your behalf. We will set a pre-trial for you for June the 10th at 2 o'clock p.m. That'll be by Zoom. If you don't have access to a video through a phone or a computer, you can go to the probation office and do it that way. Okay. We'll set your final pre-trial for July the 1st at 2 o'clock p.m. and your trial will be July 23rd at 8 a.m. You're released on your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit of $171 to cover certain statutorily required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street. Do you know where that's located?
Yes, sir.
All right, you report there immediately after court, and then you'll be required to report to them once a week for 4 weeks, and after that, as they determine. You'll be required to undergo random drug testing, provide phone number for home cell employer, recommended by probation, be evaluated for substance abuse or mental health issues. If any treatments indicated, you're to enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 13529 Cynthiana Road, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, and also attending any kind of job training, schooling, or educational programming.
Okay.
Oh, both times?
Yeah, well, one time she's on vacation, and the following week she's on vacation.
Okay. Okay, both of those, all right, I forgot.
But
Okay.
it might be, well, I don't have anything there.
All right. Okay, we're going to reschedule the, forgot Ms. Witt's on vacation. So her first pretrial will be June the 24th at 2 o'clock. And let's see, how about, well, it was July the 1st. She's back then, I think.
Yeah, we have it.
All right,
Check over in the morning.
so it'll be first is 6:24, second one 7:1. Okay. All right. If you violate any of those conditions, then the court could revoke your bond and have you held in custody until further bond hearing. All right. You have any questions?
No, sir.
All right. So now you're going to have to go out to the sheriff's department after you sign your OR bond downstairs. Well, we'll do it this way: sign your OR bond downstairs, make payment arrangements on your deposit. Then you're going to go down to the probation department, report there, and then after you're done, go out to the sheriff's office to be fingerprinted and photographed and booked for this charge. Okay? So that's an additional condition that you report to the sheriff's office immediately for booking.
Okay.
All right. Thank you.
Thank you.
Yeah. Anybody here for the 10 o'clock yet? This is case number 26CV064, Atlanta Harris versus Meredith Jones Pence. And are you Atlanta Harris?
Yes, sir.
And you're appearing without counsel,
Yes.
right? And you're Meredith Jones Pence?
Yes.
And Mr. Scott Evans is appearing on behalf of the defendant, is that correct?
Yes, Your Honor.
All right. All right, well, this was originally set as a case management conference by the court's order of pretrial management order back on March the 30th. And then there were a couple of motions filed by plaintiff and on April 23rd, and so those then were set for hearing today. The first one in order in the file is a motion by plaintiff to disqualify defense counsel, and then a motion for leave to file an amended complaint. And then on the same day, plaintiff filed a reply to the counterclaim filed by the defendant. All right, so I believe that we should address the motion to disqualify the defense counsel first. Ms. Harris, you have alleged that the defense counsel, Mr. Evans, previously represented you and obtained confidential information. So I'll receive evidence then on that matter. If you have any evidence you'd like to present. Do you have evidence you'd like to present?
I do.
All right. If you would stand, raise your right hand, and be sworn, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Absolutely.
All right. Be seated. All right. If you would state your name and address for the record, please.
My name is Atlanta Harris.
All right. Now, if you would like to go ahead and testify as to what the nature of your prior legal relationship was with Mr. Evans and the matter, about the matter, go ahead. And
Yes.
by the way, he'll be able to cross-examine you on this as well.
Okay.
All right.
He represented me prior in a divorce.
Okay. When was that?
That was, I believe it was 22, January. I believe. It could have been 21. I got paperwork for it.
Okay.
So,
Where was that?
where was it?
Yes. What county?
Here, Highland County.
Okay. All right. Go ahead.
I took notes, so I'm just
Go
going to
ahead and
read. It
testify.
would be easier
Whatever
for
you
me.
want to say. I mean, he'll cross-examine you, and I'll ask questions too.
Okay. I said, I am requesting disqualification for Attorney Scott Evans because he previously represented me in my divorce proceedings, and I believe his continued representation of a party directly adverse to me creates a conflict under the Ohio Rule of Professional Conduct 1.9. During the prior representation, Attorney Evans obtained confidential information regarding my finances, family circumstances, litigation-related stressors, and personal matters through an attorney-client relationship. The information was shared in confidence during a difficult and emotional, sensitive period of my life, information that I don't believe that he would have had he not represented me.
Okay, and how was that related to this information be related to this proceeding?
I believe that it's fundamentally unfair for an attorney who previously represented me and learned confidential information through that representation to now represent a party that's directly adverse to me, while I'm unrepresented in an emotional, contentious litigation.
And was that a contested divorce, or
Yes.
was it agreed to? Did you reach a settlement, or was it a contested divorce?
No.
Did you get divorced?
Yes.
And did your ex-husband have an attorney?
Yes, he did.
All right. And so did you reach a settlement and agree to the divorce?
Yes.
All right. Or was it a dissolution?
It was a divorce.
A divorce. All right. So there were several hearings then.
Yes.
All right. And when was it, you say you believe that, you said January 2022, was that when it was started or when it terminated?
When it was fine. That
Okay,
terminated.
your divorce was final in January 22.
Yes.
All right. And have you had any subsequent contact with Mr. Evans regarding any matters related to that? case? Been any post-decree matters come up?
No, since then?
Yeah.
No.
In that case? Okay. All right. Anything else you'd like to testify to, or any other evidence you would like to present regarding that matter?
I think that's mostly my argument.
I'm sorry?
I think that's mostly my argument. Just the conduct protects former clients from adverse representation, and I feel like he has specific information about my financial hardship, family dynamics, litigation-related emotional stress, things. That's, yeah.
Mr. Evans, is there anything you'd like to ask plaintiff?
Yes, thank you, Your Honor. Ma'am, if I ask you whether we initially met on May 14th, 2021, does that sound like you'd be about the right time frame?
The right time frame, yes.
Okay, and if I asserted that you were actually divorced on February 8th, 2022, in terms of when the decree got filed, does that sound about right? Yeah, as long as you let me know what you're referencing. So,
I have January.
okay. Are you looking at your divorce decree or a different document?
I'm checking that. Oh, final decree. Yes, February 2022.
All right.
That's correct.
And in the furtherance of that case, you submitted property affidavits regarding your finances, your assets, and debts in the marriage, correct?
I believe so.
And in that case, you ordered real estate that is publicly available, meaning it's on the county auditor recorder website.
I would assume so.
And since that case, so since February of 2022, you've been back on post-decree matters twice.
No.
Mr. Wagner was your attorney and you filed a contempt citation against your ex-husband.
Yes.
And that would have been approximately July 12th, 2022. Does that sound right?
Sounds.
And again, after that, in October 2022, you sought to modify your parenting schedule in the divorce. Is that also right with Mr. Wagner?
I believe that was all one.
Continuous course of litigation?
But yes, that was with Mr. Wagner.
And I was not your attorney in
No,
that?
you were not.
All right. And at any point in the representation in 2021 and 2022, Meredith Zorns Pence was not a witness, a party, or contemplated in any conceivable way.
A part of.
Your divorce case.
No.
And the incident you're alleging is relevant to this matter occurred on or about, pursuant to your complaint, September 19th, 2025, correct?
Yes.
And per the judge's question, we did reach a full settlement in your divorce in January 2022. Is that accurate?
Yes.
And prior to that, you mediated a partial or significant agreement before that was reached as well, correct? You went to private mediation, you and your ex-husband?
We did.
Okay. And at no point since February 2022 have you and I had any type of attorney-client relationship?
That's correct.
All right. No other questions, John?
So your divorce decree included a settlement on all property matters and assets and debts. Is that correct?
Yes.
And so everything that was there anything that you disclosed to Mr. Evans that was not filed with the court, since you're required to make a full disclosure to the court?
Not that I'm aware of, no.
So anything he would have obtained from you and your representation of you would have been filed with the court and disclosed on the record.
I will say if he filed it.
Okay. I guess what I'm getting at is, in a divorce, you're required to make a full, complete disclosure. Mm-hmm. And so if you tell your attorney information about that, then they have to prepare an affidavit, which is, because you were the plaintiff in that case, correct? You filed it against your husband? I
believe he filed first.
You filed first?
He
He
did.
filed first,
Yes.
all right. But you then had to, because under the local rule, we require an affidavit of assets, income, and debt, and that has to be filed. It's not public record, but it's part of the case file for the court.
Okay.
And then when you reach property settlement, that does become public record.
Okay.
And so in your property settlement, you reached everything that you told Mr. Evans about as far as any income or debts or property, et cetera,
Yeah.
was disclosed and made part of that agreement. Is that correct?
Yes, as far as I know.
All right. So are there any other confidential information that you feel that he would have obtained as a result of representing you in that matter?
No, I don't think so.
All right. Mr. You have anything else you'd like to present? Any other witnesses or any other evidence you'd like to present?
Not for this part.
Just for this part, yeah. Okay. All right. Evans, do you have anything you want to offer?
Your Honor, just briefly on the point you just addressed, I believe I have a duty not to suborn, perjury, or falsification in any event, so I would never submit a false or incomplete property affidavit. And to my knowledge, recollection, and dealings with Ms. Harris, there was nothing untrue or deceptive in any of the pleadings she filed in the court.
All right. Well, the legal test for disqualification of counsel in a civil case is different from that in a criminal case. And in the 4th District Court of Appeals, which is the district we're in, there's a case of Kitts, K-I-T-T-S versus U.S. Health Corp. That was decided in 1994 out of Scioto County. And it follows on pretty much the case law on most other jurisdictions. Most recently, Musser versus Youngstown Orthopedic Association. That was in Mahoning County, 2021-Ohio 4301, 2021 case. And all of the cases talk about case originated out of the 6th Circuit in 1990, Dana versus Blue Cross Blue Shield. There's a 3-part test. First, a past attorney-client relationship must have existed between the parties seeking the disqualification and the attorney that they wish to disqualify. So that prong has been met. Secondly, the subject matter of the past relationship must have been substantially related to the present case. And then finally, they must have obtained confidential information from parties seeking disqualification. Now, substantially related is defined in the Rule 1.0 N, little n, of the Higher Rules of Professional Conduct. It says it involves the same transaction or legal dispute or one in which there's a substantial risk that the confidential factual information that would normally have been obtained in the prior representation of the client would materially advance the position of another client in a subsequent manner. I will say that prong 3, as far as confidential information is that if there's an attorney-client relationship, there's generally a presumption there would be information, and then at that point there has to be an examination. Under the Musser decision, they discuss whether there's a substantial relationship between the matter at issue and the matter of former representation, sufficient evidence that to overcome the presumption of shared confidences, and in that case actually involved a law firm, so there's some other things there. But in this situation, it appears to the court that the specific claims that the plaintiff is advancing of confidential information is not confidential because it was required to be disclosed by the court's rule in the divorce case. It was disclosed. It was addressed in a document that became a public record in the settlement. So that would not be considered to be confidential information. Now, I'm sure there may have been other confidential information, but the plaintiff's made no claim that any of that has any substantial relationship to this case. So based on the case law, the court does not feel that disqualification is merited. I will say this, I don't know that I would do what you're doing, Mr. Evans, but in any event, that's certainly up to you and your client to discuss. But at this point, I don't see anything that would justify. Now, I will also make the caution here is that in the event that something occurs during the course of this litigation that you have new information or different claims of confidential information that he might have that could be raised, but it would have to be totally different from what you've raised here. So the motion to disqualify is denied.
Your Honor, can I elaborate on that? I know you've made your decision, and I accept that.
Go ahead. What did you say?
I know you've made your decision, and I accept that. But can I elaborate on maybe some other details? And I know
No,
that
you had your chance. I asked you. You can't. Don't get 2 bites of the apple. You gave your case. I heard it. I heard him. I made my ruling. So
okay.
You can't argue it over again or offer new information now at this point. But it would have to be something that's confidential that would be substantially related to this case. And quite honestly, I think it is pretty remote. I don't know that there would be anything, but generally it would happen if there's something like that was. Well, I'm not going to give you an example because you're representing yourself. All right. The next motion then is a motion to amend the complaint. And you want to, as I understand it, you want to amend to add that you're seeking punitive damages?
Yes.
Okay. Any objection to that, Mr. Evans, that it be amended to add that as a claim? Not that you're agreeing to it, but that there's anything there. But I mean, for purposes of this point in the case.
Just to preserve the record, I would object, Your Honor. I understand Rule 15 now.
All right, well, under the Civil Rule 15A, motion to amend should be freely given, and since it's basically only adding claim for damages, which from the, as a general rule, I don't know if this one, I know most attorneys, when they file motions, I know the catch-all is always any other legal or equitable relief to which the court finds the defendant may be entitled, and so that's always going in. The assumption that if you didn't ask for relief, that you're entitled to it, courts can generally consider it, particularly when the request has been added. I don't see any prejudice, so the court will grant the motion to amend.
Okay.
All right. Then the other matter that would come before the court, so what that means is you have to file an amended complaint. So I'll give you 14 days to do that.
Judge, if I may, for the record, was there a proposed amended complaint? If there was, I did not receive that. The motion referenced and attached.
No, I didn't see one. You didn't attach one, did you?
A motion?
No, an amended complaint.
I did.
You did?
I believe.
I did not receive it.
No, I don't see it. Let me look through here.
That's why I was asking.
Motion for leave to file, and I have, it's 2 pages, and that's it. And the other thing was your reply to the counterclaim filed by defendant.
I have.
All right, well, you'll need to file it. You're granted 14 days to file an amended complaint, and then defendant will have 14 days to file an answer. So if you get it done today, then that's when the time will start. But, all right. Now, the only other issue then, the case management is just basically a brief ministerial thing, and that is to see if there were any problems with any of the scheduling dates, deadlines. Do you have any problems with any of the dates that is in the scheduling order, Ms. Harris?
As of right now.
Pardon me?
As of right now, I don't.
Okay. Mr.
I-
Evans,
Good.
you don't have any?
I am in school, so
Okay.
my days have changed, but
Well, I don't know about, let's see, this is set for trial in July of next year.
okay.
So,
Yep.
so if you're in school, you'll need to make arrangements to work around that, I suppose, if it goes to trial. So, but in terms of all these deadlines, these are deadlines that you'll have to comply with. And the next one coming up is a joint discovery plan. And under the civil rule, both attorneys, since you're representing yourself, you and Mr. Evans would have to file a joint discovery plan. I went ahead and laid one out because generally, even though that rule's been in effect for 3 or 4 years, my experience is that about half the time the attorneys do it. So I just put it in there, and then sometimes they file their own. If it's different, then the court will consider it. But if not, we just follow this one. So is there any objection to the discovery plan that's in here, Ms. Harris?
No.
Do you have any objections to the dates that I said in the scheduling order for discovery?
No, sir.
You have-
No, Your Honor, and they all work with my calendar.
So then the court will consider the joint discovery plan to be the order of the court. All right. Scheduling order of the court. All right. Yeah. Are there any other matters you'd like to bring up this time, Ms. Harris?
I don't think so.
Mr. Evans?
Just one, Judge, and that's kind of the next bump on that scheduling order. June 24th generally recommends plaintiff's attorneys to initiate the call with the court that day. I don't know if the court wants to send out a Zoom link or how.
Yeah, we'll do it
for
by
that.
Zoom.
Okay, that's fine with me, Judge.
I'll make a note here for the silent issue. All right. Yeah, normally the plaintiff's attorneys are the ones that make the call, but we'll just do this by Zoom. All right. Then anything further from parties?
Not for me, Your Honor. Thank you.
All right. Thank you.